For the better part of the last 10 years, multinational companies have been concerned about the FCPA, the Foreign Corrupt Practices Act, and more recently, its near neighbor in the UK, the Bribery Act. Massive FCPA settlements have motivated companies to improve their compliance systems and the monitoring of their overseas businesses, particularly in higher risk markets where bribes of government officials and private individuals are still quite common. Now, this is all good. Companies should be concerned about such legislation. However, we are seeing a sharp increase in the enforcement of local regulations in some of these same higher risk markets. Take China, for example. In 2013, the British pharmaceutical company, GlaxoSmithKline, was investigated for, among other things, giving bribes to doctors. They were eventually convicted in Chinese courts for having violated Chinese anti-bribery laws. The FCPA didn't figure into it at all at the time, although it certainly did later. Following on from this, other multinational corporations were investigated and convicted under Chinese regulations for anti-monopoly, environment, food safety, pricing, and taxes. Even now, there are several ongoing local cases in China in which MNCs are struggling to defend themselves. The challenge to MNCs is exacerbated by the simple fact that in many of the most challenging markets in the world, the regulatory environment is rather opaque, and the investigative and prosecutorial powers of the regulators is often quite broad. So you have a very high-risk situation where vague laws are aggressively enforced. Now, the first thing companies should do is take a fresh look at the regulatory environment in their biggest and most challenging markets. We are helping many clients go beyond what the law says, or what the lawyers think they might say, in high-risk markets, and look to see who is enforcing them and how the enforcements are carried out. We effectively put ourselves in the regulator's shoes and help the client view their businesses from the regulator's point of view. In this way, we're able to determine the places where our client might be investigated and why. This enables them to put mitigation plans in place immediately to reduce the likelihood of being investigated and the impact if it does happen.